Here we are going to discuss about the Anti-Defection Law. Supreme Court of India is currently examining the effectiveness of Anti-Defection Law and also the timeline of speakers to decide on the disqualification petition. So this issue has sparked discussions on the effectiveness and the implementation of Anti-Defection Law, because this law plays a crucial role in maintaining the stability of governments. So in this context, let us discuss about the basics of Anti-Defection Law. See, Anti-Defection Law was introduced in 1985 by 52nd Amendment. It was added to 10th schedule of the Constitution. The primary purpose is to curb the political defections. So this is by ensuring that legislatures remain loyal to the party from which they are elected. This law applies both to the parliament and also to the state assemblies, and it gives power to the presiding officer, that is the speaker or chairman, to decide on the disqualification on the grounds of defection. So the deciding authority of disqualification is the presiding officer, which may be speaker or chairman. So this law applies both to the parliament and also to the state legislatures. The Anti-Defection Law has several grounds for disqualification. The legislature can be disqualified if they voluntarily give up their party membership or disobey the party whip. For example, if they abstain from voting or voted against the party's direction, then it means they have disobeyed the party whip, and this is one of the grounds for disqualification. Additionally, the nominated members who join a political party after 6 months, they can be disqualified, and also the independent candidates who later align with the political party also face disqualification. So these are the 4 important grounds based on which the disqualification petition is filed to the speaker. This Anti-Defection Law also includes an exception. If at least 2/3 of the party legislatures agree to merge with another party, then this is not considered as a disqualification. If few members or one member decided to join another party or betray their party, then it is disqualification. But if 2/3 of the party members decided to shift to the another party, then it may not be considered as disqualification. So this is an exception for this law. One of the major concerns regarding the Anti-Defection Law is the lack of time limit for the speaker to decide on this disqualification petition. So there is no time limit for speaker on when to disqualify or to decide on the disqualification petition. So this has led to cases where speakers delay decisions. Sometimes they also benefit from the ruling party. Even though the presiding officer's decision is considered final, it is subject to judicial review. So this is an important point. The deciding authority, the final authority to decide on the disqualification is the presiding officer, either speaker or chairman. But his decision is subject to judicial review, which means it can be intervened in the court if it violates a constitutional principle or natural justice. So this is an important point, please note that. Now we shall look about the key cases regarding the disqualification. The most important one is Kihoto Hollohan case. In this case, the Supreme Court held that the speaker's decision is subject to judicial review. The next one is Keisham Meghchandra Singh case. In this case, the court emphasized that speakers cannot indefinitely delay the decisions. So the speakers have to make a decision on the disqualification petition at some time, within a considerable amount of time or a reasonable time. So they cannot sit indefinitely on the petitions. So these are the 2 important cases regarding this Anti-Defection Law. With this, let us conclude the discussion. Let us discuss an MCQ related to this topic. Consider the following statements. The Anti-Defection Law allows the speaker to take final decision regarding disqualification. Yes, this statement is correct. The Supreme Court has ruled that speaker's decision is not subject to judicial review. No, it is subject to judicial review, and this is said in Kihoto Hollohan case. So the correct answer is option A, 1 only.